that his attorney, his own attorney, says, get out of my office. You didn't feel safe. What did you do for safety reasons?
We locked our front door. I excused my staff, whoever didn't feel comfortable. I arranged for my office to have active shooter training and also paid for my entire staff to be trained handgun shooting.
Did you advise Mr. Allen that he was being recorded?
No.
It is not within my jurisdiction or purview to determine whether or not you made a threat with the intent to do whatever, right?
In Bexar County, Texas, Ronald Lamar Allen appeared before Judge Stephanie Boyd on a criminal charge involving an alleged terroristic threat. At the center of the case was a recording made inside his own attorney's office, without his knowledge. Attorney-client privilege is one of the most protected relationships in the legal system, but it is not absolute. There are limits to what a client can say inside that office and still expect it to stay confidential. That limit is exactly what brought this case to court. The defense filed a motion to suppress, arguing that the recording violated the confidentiality of that attorney-client relationship. Alongside that, the defense filed a motion to dismiss, leaning on landmark Supreme Court decisions to argue that the First Amendment draws a clear line between protected speech and what the law defines as a true threat. The state had its own Supreme Court authority and 2 witnesses ready to challenge every argument the defense put forward. So now the question was clear. Where exactly does the line fall between confidential and criminal? That answer was about to be tested before Judge Boyd, and both sides came prepared to fight for it.
All right, if you'll state your name for the record.
Charles Michael Ireland Jr.
All right, you may proceed, defense.
Mr. Ireland, were you Mr. Allen's attorney during a portion of his family court case?
Yes.
And the meeting, where was the recording made?
In my office.
All right. And so the conversation, you would agree that the conversation that you had with Mr. Allen was attorney-client privilege, correct?
Yes.
Well, that's all I have for right now, Judge. I'd like to pass the witness.
All right, state.
You on direct stated that you agreed the conversation was attorney-client privilege. Is that true?
Yes.
Did you believe the entire conversation was attorney-client privilege?
No.
What sorts of things are not privileged under that attorney-client privilege?
Mr. Allen said some things to me that I believe clearly established that he was going to attempt to or commit an act that would cause bodily harm or worse to one or more individuals.
Do you recognize Rule 503 to be the rules of evidence for attorney-client privilege?
Yes.
And in that rule, there is an exception. That's true, right? There's multiple exceptions.
There's multiple.
There's an exception that says the privilege does not apply in furtherance of a crime. Is that true?
If you say so.
Well, in this conversation that we're about to hear, something alarmed you. Isn't that true?
Yes.
And you believed that the attorney-client privilege no longer held because of that statement.
I believe that because of what was told to me, I had a mandatory duty to report it to authorities.
Your Honor, at this time, state is going to play what has been entered as Exhibit 9. It is around 12 minutes, 54 seconds. We'll play the entire thing.
Thank you.
I'm going to show you. Hey, I think we're in the courtroom. Your face has so fucking easily. If you was so fucking. Do you have this or not? Nervous? Yes. You look nervous. You were very scared.
It has paused it at 45 seconds. Whose voice do we hear in this recording?
Mr. Allen's and my voices.
May you point out and identify Mr. Allen by an article of clothing for the record?
He's a gentleman over there in the orange jumpsuit.
The record may reflect that our witness has positively identified the defendant in the courtroom. And the second voice, whose voice is that?
That's mine.
The state will resume playing at 45 seconds.
Fidgety and not look at your face and you were so red and blotchy, like when somebody gets put on the spot or something like that. Can you handle this? Because history's going to get made Wednesday. Right? I don't have to deal with this after Wednesday. I know for a fact. How are we going to do that? The answers we need already happened. You know how I know? Because I can't keep a message at the beginning of this. And I told him, you're playing for the wrong judge. There's only one judge and it's Hayden. I have all the evidence. As soon as I did that, I've never seen him again. They know it's there. That's why they're rushing around. I got called into jury duty the same week in the same courtroom. The odds of that is like me winning the lotto 20 times in a row, bro. It doesn't happen. There was 2 girls in that courtroom. Those 2 girls are the same ones in that hallway when they didn't show up in the court and we were talking loud in the hallway. They were fucking, and they asked me over and over and over, does anybody recognize anybody? Does anybody recognize anybody? Over and over and over. Those 2 girls and Justin was up my ass. Are you in on this or not? because I'm gonna call the FBI tomorrow. Because I don't know who else calls, because I've talked to you and still nothing has been done.
If you're not happy with my services, you can fire me, but I'm not gonna sit here and be questioned about whether I've got this or not.
Well, you know what? Why haven't you called the DA? Because there's definitely
What criminal charges? I'm a civil.
Okay, here, that same lady who's signing all these things.
What things?
Okay, this guy, he's got a TRO, right?
Medley?
The ex-boyfriend or the boyfriend,
Oh,
He's got-
Sherwood?
right? And it's sealed, right?
Yeah.
Why would you seal something? And because if you don't care about it, if it's her,
No,
you would still
protective
have
orders are
kids.
sealed by law. There's a
Okay.
statute.
Okay. So that's happening at the house. I guarantee you the same month, that same judge who signed that for her signed something that says I can't have Aiden or something. And it's there. We went to court that same month. How does that not show? That judge, they're there every day. It shows. That's a huge conflict of interest right there. What happened is Tiffany didn't need a signature and she went and did this. Torres signed to keep her ass out of jail. And then what you got is Torres, the next 2 times she ruled in my favor because she had to. Didn't stop Tiffany from bringing her. Tiffany already knows she's not going to get in trouble. That's why she's not doing this. And they're looking there trying to set up in the thing so I fuck up. And they're putting me in a bubble. Do you see that at KidShare? Every time I hit the KidShare, it's, oh yeah, nobody called me or nothing said there was going to be a cancellation until I get up there. And then I hear half the story. Then I go the next day and it's, oh no, the whole weekend. Oh, you talked to her again? No, we talked to her that day. You said she just wasn't going to show up that day. And then, you see what I'm saying? The information goes. They're creating a scenario for me to make a scene. And I'm not going to see Aiden until that happens. There's no doubt in my mind.
So nothing about this case scares me.
Well, I'm scared,
Okay, I mean, I think that's healthy.
but not about Aiden.
What are you scared about?
I'm scared for my life, dude.
Okay, why are you?
Because
scared
there's
of your
something
life?
there. There's something there. There's something there. There is something there. We're overlooking something. You cannot tell me all this stuff that's going on. I see extortion. I see
Oh no, I mean,
kidnapping.
I think you're getting fucked for sure.
I see kidnapping. I see extortion. I see obstruction of justice. Dude, all this stuff. Tiffany falsified that document and just presented it on me. He gets a signature from Torres, and then Torres gets my case the next 2 times in a row. What are the odds of that? How many times do I have to do this? Right. And then I have jury duty, and then they're asking if I'm
When did you have jury duty?
the next week. I
Just
just
a
have
few
this
weeks ago?
last week, bro.
I didn't know you had jury duty last
Yes,
week.
that's it. Nobody's telling you everything, dude. Yes, I had jury duty, dude, and Justin was it. There was nobody else. Nobody else. Dude, they asked me certain questions. They made me sit there all day.
Whose court was it in?
Same f***ing judge.
Torres?
Yes.
Oh,
That's what I'm saying. The odds of that happening is they wanted to know what I knew. Or if I recognize those other 2 girls. They're fucking relaying message. When I go to court and they don't show up and they hit it from Zoom, they've got 2 lawyers in the hallway talking about our deals. Justin was next to me the whole. If I was Justin, I wouldn't want to see me. Justin was next to me the whole time in the hallway. He wanted to know what the I knew and who I was. There's no doubt. There's something there. And the fact that
are you talking the 2 girls who were sitting outside when we went to court?
no, I know exactly who they are. They represent Via. It's 2 girls.
Okay.
And at the end, the judge gave a long speech about you got to see our, how we work and blah 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 this and blah 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 that, and this and that. That one girl, mad dog, ain't they ever living shit out of me the whole time. And then the other girl was like, just talking or whatever. But we're listening to the judge. The chubby girl didn't really. She was the one asking questions. The other girl, she didn't look at me the whole time. And then at the end, when that judge was giving that speech, it was like it was directed towards me. And she was mean mugging me the whole time. Who does that? You know what I mean?
Do you want to know why I was mad when we were there and my face was red?
Why?
Because I knew we weren't going to get a hearing. Because we sat there and we sat there and we sat there.
And it's not going to happen. I know Wednesday, something changes.
I hope so.
And it's in my favor. We're going to find something. It's there.
Well, I've been arguing with Martha for 3 days.
Martha is a distraction. They're doing that to distract you from looking for what you need to be looking for.
Come in.
There's no doubt in my mind. These guys are tricky.
So it's the subpoena for Sherwood.
Who?
Sherwood.
Allen?
Yeah.
Absolutely.
Is he friendly to us? You think he'll be friendly to us?
Yeah,
we're about to send it out.
Yeah, I've never done anything to him. Why wouldn't
Do
he?
you have a phone number for him?
No, I don't know.
We just have that address.
Absolutely, because you know what? She's following the exact same play. It's like Medley talked to her and showed her the blueprint, and they've been following it to a T. She was with him. They broke up because there's a protective order, obviously there. They got back together because I run into them at the at the Target or whatever. And then he's gone. I tells me, Alan's gone or whatever. She's pregnant. Now she's got something to hold over his head and take money from him and extort him just like she's doing to me. That's exactly what happened with me and A. I kicked her out on 4th of July. She said, can we get back together? She went, made a Bakeland police report, said I choked her, and then figured out that there's nothing she can do. She would have to go back home to her parents' house. She called me offshore that same day. That testimony, but that recording, she spends more time talking about how do I get this guy to pay and me stay in this big ass house in Wimberley and him never coming home again. And she calls me her spouse. She doesn't even refer to my name in this thing, okay? This is from the very get-go, and she forced me to it. She said, save our family, sign the deal. So I signed it. The next thing I know, she turned it around, and I've been fighting for Aiden ever since. She's gonna do that with Alan. The exact same thing. She did it with the other guy.
I'm assuming you haven't heard from Esparza.
No.
I'm assuming you haven't heard from the amicus.
Right, and I mean, all this together, doesn't that paint a pretty big picture? They're refusing to sign this, they're refusing to do that. After they were on my side, the only reason they came on my side is so they don't look so guilty. But yet I got $2,000 bills all of a sudden from the amicus and this and that.
Yeah, I don't know how you said I got that.
See what I'm saying? It's extortion, it's kidnapping. Everybody's dirty on it. They called me into jury duty, bro. I mean, jury tampering. I guarantee it.
Here's the deal. I'll do whatever you want me to do. I will go there and fight whatever fight you need me to fight.
I think that we need to get somebody else involved. Okay, so we get all this information. Who are you gonna take it to?
To the judge, that's the only place I can take it.
The same judge that's dirty?
Well, I don't know who the judge will be.
Well, Mark already said, and I heard him, watch this little trick. He's gonna go down Wednesday. We're going to. I promise you. He said we're gonna.
Torres
He
or
said,
Nieto.
to skip per sightings, right, Judge? That's the last thing he said in that courtroom.
But that's not in the order.
I know, but that's what he said, and he's done this to me every time. Why do I have the same judges over and over and over?
I don't know.
But that's because we keep going to the same ones. He does. He's gonna
So
look at
what he can do Wednesday is he
Check it out, check it out. I've been in the court a million times, all right? And I knew I was gonna do this. How did I know? Somebody told me. I know I'm gonna sound crazy or whatever, but I know these things. So if I was gonna do that, and I knew all this stuff was gonna happen, I'm prepared for Wednesday. But something is going to happen that's going to change history, whether you bust these guys or there's dead bodies everywhere, bro.
Okay.
Because I'm not living in a real world where I'm telling you all this stuff is going on and you're still not doing anything about it, like going anywhere. Not letting anybody. You have a suspicion that these guys. You told me you're on a counsel for corruption and all this stuff, but
No,
you
it's not
haven't
a
even
counsel
let
for
nobody know. Maybe I have something and they can kind of help you
It's
on
not
this.
counsel for corruption. It's a-
Whatever. My point. The only person who knows about this is you, and I still don't have my son, and they're refusing to sign something. That doesn't even sound right to me.
I agree with you.
Okay, so who do we talk to?
We have a hearing on Wednesday.
Yeah, we do.
And beyond doing my job, Ryan, I don't know what you need me to do, man.
It's criminal.
I don't disagree with you.
You're civil.
Right.
Where's the criminal? You haven't even let them know you have suspicion. That's what I'm getting at. You look nervous in that courtroom. You went in there and nobody else went in there but you and everybody else and not me.
I asked for your permission. You said I
did
could
ask for
go.
my permission, and you did walk in there. And ever since then, I'm still getting screwed.
All right, get out of my office.
See you later, buddy.
The state has paused at 12:20. Mr. Ireland, what did you take this statement? I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. What did you take that to mean?
I believe that was a threat that if he didn't get what he was seeking, that people would be hurt.
You're familiar with threats like these. That's true.
Yes.
What do threats like these look like?
I've been a family law attorney for almost 13 years. I've been threatened before. I think you have to take every threat seriously. So when those words were said, I believe them to be a real, true threat.
All right, State's Exhibit number 2 is admitted without objection for purposes of this hearing.
In the recording we just heard at 57 seconds, defendant says history is going to be made on Wednesday. Tell us the significance about that Wednesday date.
That was the date we were set for a temporary orders hearing. Mr. Allen had up until that point supervised possession and access of his son, and we were hoping to get unsupervised possession and access.
You did not have a scheduled interview with defendants on the day in question. That's true.
That's true.
Why did you accept this interaction with defendant when he hadn't had a planned meeting with you?
I had availability in my calendar. I had about a half hour to 45 minutes available, if I remember correctly. And I knew he was anxious about the hearing, and so I thought I'd give him some of my time to hopefully make him feel better.
You had never recorded a conversation with you and Mr. Allen before. That's
No.
true.
That's correct. That's correct.
It is not your normal practice to record conversations with clients.
That is also correct.
After defendant said, I'm prepared for Wednesday, something is going to happen that's going to change history, bust these guys or there's dead bodies everywhere. Who was the first person you called after that?
I called the State Bar Ethics Hotline
What were you advised?
that I had a mandatory duty to report what was told to me to law enforcement under Rule 105E of the Texas rules of the disciplinary rules for attorneys the ethical rules that we live by.
Why did they say you had an ethical duty to report?
Because the State Bar Ethics Hotline believed it met the standard in 105E.
Did you call anyone else?
Yes.
Who?
My attorney, Carl Cobb, that's KOLB.
What did attorney Cobb advise you?
I provided him the recording, and then he advised me I had a mandatory duty to report it to law enforcement under Rule 105E.
Do you remember speaking with an investigator, Lopez?
Yes.
When you initially called to report, you told Lopez your fear of the threat that there were going to be dead bodies everywhere, right?
Yes.
You did not tell Lopez anything about any attorney-client privileged information.
No.
The recording we just heard, its total duration is 12 minutes, 54 seconds. It was at 10:45 that defendant said there's going to be bodies everywhere. How did you respond to that statement?
I was in shock. That was the second time he had said, we're going to make history on Wednesday. And I think at some point, even in my head, I said, don't say it. And then he said it, that there would be dead bodies everywhere.
After you reported this threat, what else did you do?
That day,
Well, you didn't feel safe. What did you do for safety reasons?
we locked our front door, and I excused my staff, whoever didn't feel comfortable being there.
Any other precautionary measures?
That day, no.
How about in the near future?
I arranged for my office to have active shooter training, and also paid for my entire staff to be trained in handgun shooting.
You would agree with me that throughout this 12-minute 54 conversation, you agreed with a lot of defendants' statements and paranoia. Isn't that true?
I don't know that I agreed with the paranoia. I had felt like up to that point that Ronnie had gotten an unfair shake in the civil courts.
You had mentioned when defendant said, I'm scared, you agreed. This is a scary thing, right?
Well, I thought he was talking about he was scared about losing his relationship with his son. And as a parent, like, I get that.
When defendant was talking about things are being overlooked, you agreed. You said, I think you're getting fucked for sure.
So that statement was because I thought, like I said, I thought he was getting an unfair shake in the civil courts based on my experience with Mr. Allen up to that point.
3 times defendant alludes to a specific date. What date was that?
I don't know. I don't remember.
When would dead bodies be everywhere?
I presumed based on the subject matter of the conversation, it would be on April 23rd, that Wednesday at the hearing.
At 57 seconds, history is going to be made on Wednesday. You remember defendant saying that?
Yes.
6 minutes, 52 seconds. I know Wednesday something changes in my favor. You remember that?
Yes.
10 minutes, 45 seconds. I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. Do you remember that?
Yes.
At this hearing in State's Exhibit 3, it had something to do with a motion to withdraw as counsel. Is that true?
That hearing? No, that was not for my motion to withdraw as counsel.
Thank you. What was this hearing for?
That was the continuation of the final protective order hearing that Miss Allen had filed against Mr. Allen, and I testified that day.
There was discussion about a motion to withdraw, though, wasn't there?
Mm-hmm.
And when asked about that motion to withdraw, you told the court that the defendant made a statement that you reasonably believed, led you to believe that the defendant was going to commit a crime that would result in the death or substantial harm to another person. Isn't that true?
That's true.
Now, defendant never said, he didn't give a specific manner and means, didn't give a specific person. But what contextually made you believe this was an actual threat?
Twice he said, I'm going to make history on Wednesday. He said something was going to change. And when he made the statement, dead bodies everywhere after he said he was going to make history, that specifically.
You mentioned playing the recording for your staff. That freaked them out, didn't it?
Yes, they were all very concerned.
Objection, hearsay.
Right, that'll be sustained.
Your Honor, the state kindly passes the witness.
All right, defense, you may proceed.
Mr. Ireland, you testified previously that you reported Ronald Allen during this visit to your office on April 24th or 21st of 2025. That's established. You recorded him.
Yes,
And you didn't advise Mr. Allen that he was being recorded, did you?
Objection leading.
All right, that'll be sustained.
Did you advise Mr. Allen that he was being recorded?
no,
And when you testified under oath in the civil court, you said in that transcript we referred to earlier, you said, when you said something inside you said to record it, what was it inside of you that made you think that that was going to be said in this interaction you had when he came into your office?
I didn't think anything was going to be said.
Do you ever record any of your other clients? Ever? You've never recorded another client?
Maybe once or twice in the 13 years I've been practicing.
And the last client you recorded, was he referred to the police for making a threat?
Objection, Your Honor, relevance.
That'll be overruled.
I've never had to do what I did in this case.
Would you agree with me that in the actual recording, there's no real yelling or threats? In fact, it sounds like an attorney this is like a conversation between a pair of friends. Did you see it that way at all? Ronald Allen thought of you as a friend and an ally in the custody case. Do your clients usually see you as a friend and an ally in their custody case?
I don't make friends with my clients while their case is active.
You have a friendly way of speaking to them, don't you?
Yes,
And if you say to Mr. Allen, I think you're man, does that mean that literally he's going to get raped or something? Or does it just mean in a figurative sense?
Objection, Your Honor, speculation and compound.
That'll be overruled.
In a matter of speaking, when you say something like that on the record and you know you're being recorded, do you think that it should be taken as a literal sense that he's going to go and get raped in the court? How do you mean that when you say it?
as I said earlier, I believed up to that point, Mr. Allen had gotten a bad shake in the civil courts.
Did you ever give a written statement to law enforcement about this alleged threat?
What do you mean by written statement?
Did you ever write something out and swear to it and give it to the investigators?
No,
Isn't it true that you emailed or texted the audio file to Che Lopez, the investigator for the state?
yes, I did.
Objection, Your Honor, leading.
That'll be overruled.
I think I can ask leading questions here because I'm on a redirect, right?
No,
Okay.
not on redirect.
Did you password protect the file to ensure the chain of custody on the MP3 that you sent to the investigators?
Objection, Your Honor, leading.
I'm just asking him a question.
All right, so I'll just make a ruling on objections that are made. So that objection will be overruled. You can answer that question.
I don't recall.
Is this the first time that law enforcement was ever involved at your initiation? Like that you called the police and had them?
In my professional life?
Yes, as a lawyer.
Yes.
So would you acknowledge that your decision to disclose these communications that you had with Ronald Allen, was that solely based on your belief that Mr. Allen might commit a future crime?
No, because I believed that what he told me clearly established that he would.
Did he have any weapons on him?
I don't know.
Is there anything in your family law questionnaire that asks if somebody owns firearms?
Objection, Your Honor, relevance.
Relevance?
Well, I want to know if he anticipated that Mr. Allen had the means or ability to carry out any kind of threat.
All right, you can answer that question.
My intake form does have that question type of questioning.
And did you know that in your review, you reviewed the entire docket sheet and history of Mr. Allen's custody case that he had with his son, Aiden, right?
Yes.
And you knew that it was a long history that was going on, didn't you?
Yes.
And you knew that, and you've already said in this court that you didn't think he was getting a fair shake on the whole matter.
Objection, Your Honor, leading.
All right, that'll be sustained.
Now, did Mr. Allen, in the recording we all heard, did he ever mention any specific names or intended victims in his narrative, what he was talking to you?
No.
Who else could help Mr. Allen, other than a lawyer, understand if I'm suspicious of some coincidence like we're talking about here, being called for jury duty the same week as your trial? If I'm trying to figure out if that's a coincidence or not, and it has to do with things that happen in the courthouse, don't you think that it's appropriate that he would call out that kind of suspicion to his lawyer?
Objection, Your Honor. That's speculation as to what asking us to,
I'm trying to explain the question.
and the state is saying this is an inappropriate question. This is,
All right.
it's
I'll-
leading and speculative.
All right, I'll let him answer the question.
It's a weird coincidence, yes, but jury summons are sent out weeks in advance. That hearing had only been on the books for about 10 days.
Mm-hmm.
So some notion that it was some sort of conspiracy can be swept away very quickly.
But you didn't tell him that in that recording that we just heard, did you?
Nope.
Do you wish you had?
Objection, Your Honor, relevance.
All right, that will be sustained.
You never attempted to, did you ever attempt to refer Mr. Allen for any mental health treatment prior to recording him that day?
No.
And did you contact Miss Anna Hesbrook Ramirez the same day as that recording was made?
Objection, Your Honor, relevance.
That'll be overruled.
Did you contact Miss Anna Laura Hesbrook?
I don't remember.
Did you text Mr. Allen back to your office before recording him? Does your office ever text clients?
All the time.
Did you ever text Mr. Allen to your office before this recording?
I don't understand what you mean, text them to my office.
Send him a text saying you can come into the office now? Did you send him a text?
I don't think so.
You said you agreed with him regarding the coincidence being alarming, didn't you?
Objection, Your Honor, leading.
You said that, or did, pardon me, go ahead, Judge, sorry.
That would be sustained. No problem.
Who is Esparza in the recording? They're talking about Esparza. Who's that?
Dr. Fernando Esparza, he's a forensic psychologist in San Antonio. I don't remember why he was appointed by one of the judges. I don't remember what his role was, though. I don't believe it was for a psychological evaluation. Dr. Esparza does many things in family law cases. Psychological evaluations is one of them.
Was he evaluating the child?
I don't remember.
When he was talking about the two girls that were in the court that represent Via, that were mad dogging him, mean mugging him, do you know who he was talking about?
No idea.
Had you had any prior meetings with Mr. Allen before that day?
Yes.
Did you ever record him in any of the prior conversations that you had with him?
No.
Did you feel like he was questioning your role as his lawyer at that meeting?
I think a little bit, yeah.
Because in the beginning, he says, well, in the beginning, you said something along the lines of, well, if you're not happy with me, you can fire me. You said something like that, right?
Yes.
And so very early in the conversation, did you believe that you were on the defensive?
I don't know about on the defensive. I was just trying to reassure Ronnie that I wasn't scared. And, I've been doing this a long time, and I didn't particularly care for the way he was questioning my tactics, I guess.
But you stayed in the room with him for several minutes after that comment, right? I mean, it was a while.
Objection to leading.
All right, that'll be overruled.
Did you stay in the room with him for several minutes after that comment?
Approximately 13 minutes, however long the recording is.
You didn't feel, did you feel alarm or feel threatened yourself personally in that moment?
When he said there would be dead bodies everywhere, yes.
Did you ever tell the police that Ronald said, if I don't get custody, I will make history and there will be dead bodies everywhere? Is that what you told the police exactly?
I don't remember. I might have.
Did Ronald ever describe any kind of plan to execute the dead bodies in the courthouse? Did he give you a plan?
Objection, Your Honor. This answer calls for hearsay.
That will be overruled.
The last time I talked to Ronald Allen was that recording. Anything before that is attorney-client privilege.
Did you have a written contract with Mr. Allen as a lawyer?
Yes,
And your contract, does it include language that communications with a client are confidential?
yes.
Objection, Your Honor, outside the scope.
That'll be overruled.
It's a contract, Judge, and
I overruled the objection. You can answer. You can answer the
Um,
question.
do you have that kind of term in your contract?
Yes,
Were you paid to represent Mr. Allen in that custody case?
it was.
And you received funds from him or on his behalf in support of that contract, right?
Yes,
And have you refunded any part of Mr. Allen's retainer?
every cent of his retainer that was remaining in my trust was immediately returned to him.
That's all I have, Judge.
All right.
That's the witness.
Any recross?
Perhaps briefly, Your Honor, I may have one moment. Your Honor, the state is done with this witness. No further questions.
All right. May this witness be excused?
Yes, Judge.
From what I'm reading from the motion, counsel, with regards to your motion to suppress, subtitle 2 and 3, both parties have stipulated that there was a warrant. With regards to 4, the real question is whether or not this was attorney-client privilege. And is there anyone who disagrees that if an attorney presumes or assumes that a threat is being made, that is not a part of attorney-client privilege?
That's how the state understands that exception.
All right, defense, do you want to address that?
Yes.
The state does have one witness to call.
Oh, so you have another witness for the motion to suppress?
Yes, Judge.
I'm so sorry. You may call your next witness. You may call your witness state.
And state is going to call Investigator Lopez, badge number 142.
Okay. State, you may proceed.
Do you remember the date, April 21st, 2025?
Yes, sir, I do.
Why do you remember that date?
It's when this case was first assigned to me.
And what is this case about?
Threats to the courthouse.
Do you remember hearing a recorded statement as it is related to this case?
Yes, sir, I did.
How did you get this recorded statement?
This case was initially brought over by SAPD Fusion, which was then given to my supervisors. My supervisors assigned me, and that's when I made a phone call to Mr. Ireland.
And who is Mr. Ireland?
Mr. Ireland is our witness and also Mr. Allen's attorney.
Did you hear the recording?
Yes, sir, I did.
What was alarming about the recording?
During the context of the conversation, he advised that the court and the court officers were, he was in contention with them. He believes that it was him against the courthouse, if my understanding of the audio recording was correct. And then later on, he stated that there will be something going on Wednesday and that there'll be bodies everywhere.
But we would object to this as to hearsay. We already heard a direct witness.
State.
Your Honor, we were merely asking how the investigator came to know about this case and his familiarity with the recording, and he has corroborated what this court has heard.
All right, that objection will be overruled.
Your understanding with terroristic threats, were those elements met even without the specific manner and means?
I believe so, sir. The threat was in reference to the trial if it did not go a certain way. And I believe he was inferring that he would disrupt proceedings or he wanted the proceedings to go his way.
And what was the threat if proceedings did not go his way?
Dead bodies everywhere.
Did you generate a warrant for the arrest of the defendant?
Yes, sir, I did.
Your Honor, the state kindly passes the witness.
All right, defense.
Did Ronald Allen ever disrupt any proceedings in the courthouse, to your knowledge?
Not that I'm aware of, sir.
You didn't observe him disrupting any proceedings?
Objection, Your Honor, leading.
I'll let him ask. You can answer that question.
I did not witness.
And did you speculate as to any means that Mr. Allen's might have had to be able to effectuate this threat?
No, sir.
Were you there when the threat was made?
No, sir.
Did you speak to anyone else related to the custody case? regarding this incident?
Objection, Your Honor, relevance.
That'll be overruled. You can answer that.
I subpoenaed, but I did not get any records from KidShare. So no, I did not speak to anybody in reference to the custody case.
Did you ever interview Mr. Allen regarding this incident?
No, sir, I did not.
In your report, you said that there would be dead bodies everywhere, but did you see that that's a misquote to what's actually said in the recording?
That's what I heard in the recording.
So would you be surprised if the recording said something different?
I listened to that audio recording several times, and to the best of my knowledge, to what I heard, that was correct.
That's all I have for him now, Your Honor.
All right. Any further questions?
No further questions from the state.
Any other witnesses from either side?
None from the state, Your Honor.
Defense?
None from defense.
All right. So what we'll do is we'll come back tomorrow and I'll hear arguments from both sides. And if both sides will be prepared to argue the motion to dismiss as well as the motion to suppress. And as stated, we'll take up the motion to suppress first. I'll make my ruling and then we can take up the motion to dismiss.
Thank you, Judge.
All right. Thank you.
Yes, Judge, we're calling Ronald Lamar Allen. Why did you say what you said in that recording?
Because I felt like the judges and the lawyers weren't taking this matter serious enough. I think that they were the reasons why my cousin committed suicide. And I believe that all the violence and all the murders that are with the family cases are because of they're toying around with it. And I think that there's dead bodies everywhere because of it. Every family situation, murder suicide I see on the news was related to a family dispute gone out of control. And that's what I was referring to.
And how many times have you been in the civil court?
236 times.
And that's how many temporary orders and settings that have been made?
Yes, sir.
236
Objection, Your
times?
Honor.
Yes, sir.
Leading, but also this is outside the scope of this hearing.
All right. That will be sustained.
Do you possess any firearms?
Nope.
Other than your ex-wife, has anybody else ever accused you of being violent?
Nope.
Objection, Your Honor, relevance.
Sustained.
What are your feelings towards Mr. Ireland now?
Objection, Your Honor, relevance.
All right. How is this relevant to the motion to suppress? And I understand the rules of evidence and that privilege, communications of privilege. I understand how that relates to motions to suppress. And I understand that technically the rules of evidence do not apply to motions to suppress outside a certain number of rules. But with regards to this, how is this relevant to anything about the motion to suppress?
I think it's worth it for Mr. Allen to be able to say how he feels betrayed by his civil lawyer.
All right, that'll be sustained.
How many other civil lawyers have you had?
At least
Objection,
20
Your Honor.
something.
How is this relevant? And this is outside the scope.
All right, that'll be sustained as to outside the scope of the hearing.
Well, Judge, I think that's kind of a hard item. I mean, we've acquiesced to let him testify in this suppression hearing because we think that he has an expectation of privacy regarding his communications with his own lawyer.
All
He
right.
should be able to talk about that, we believe.
Well, with regards to his expectation of privacy, because I'll note for the record, this hearing is a combination, I believe, of the motion to suppress and the motion to dismiss. So I will take this hearing as a combination of your motion to suppress and the motion to dismiss. Is there any objection from either side to the court hearing evidence for both of the motions at the same time?
No objection from the state.
I'm not opposed, Judge.
All right, if there's no objection from the state and the defense, then because you all are saying that you want the motion to suppress and then the motion to dismiss heard at the same time, then I will hear testimony from the witness with regards to your question of expectation of confidentiality.
And we think that's the efficient route.
Okay. All right, you may proceed.
Mr. Allen, you had so many different lawyers on your cases. have any of them ever disclosed confidential information to the opposing counsel, to the representative for the child, or to the court generally?
The state is objecting to relevance outside of the scope. In support of that, we're talking about representation from other people. This is not relevant, and it does not go to what Your Honor has narrowly allowed expectation of confidentiality. This is outside the scope.
All right, so counsel, that objection does not pertain to your motion to dismiss or to the motion to suppress. So response
Well,
as to what other attorneys did.
I think it is relevant because it tends to, we're talking about an experienced person in relation to attorneys and what kind of expectations that he has regarding privacy and what is typically contracted in a civil attorney contract.
Right. Well, you can question him about his expectation of privacy as it relates to Attorney Ireland.
Okay. Did Ireland ever call you and ask you anything about your statements made in the office and the recording we heard?
No, he did not.
Did Ireland ever tell you that he was going to call the amicus attorney or call the police regarding what you said?
No, he,
Objection, Your Honor, relevance, but also an appropriate witness. We had Mr. Ireland on the stand and all these questions. There's a better witness for that.
He's a party to that conversation, Judge.
All right, I'll let him answer the question.
no,
Did Mr. Ireland ever ask you what you meant in that moment?
no,
Did Mr. Ireland ever express any fear or recoil? Did he act scared when you were in that meeting with him?
no.
What were the last things that Mr. Ireland told you at the end of that recording?
Get out of my office.
What do you expect when you walk into an attorney's office?
What do I expect when I walk in? Well, confidentiality, of course.
Do you expect that the attorney's going to be on your side?
Absolutely. Or you sign a contract with them. It's there.
Did you have any means to execute any kind of threat?
No,
Did you have any kind of intent to threaten anybody in the courthouse?
no,
Did you have any intent to threaten Mr. Medley?
no.
Did you have any intent to threaten your ex-wife?
Objection, Your Honor. It is beyond the scope of both motions.
Our motion to dismiss talks about mens rea and the intent in the mind of the accused. And so I think if he's taking the risk of subjecting himself to a cross-examination from Mr. Duffy, well, then he can ask his questions as much as he wants
Well,
on
what-
redirect.
What I can tell both parties with regards to mens rea and whether or not he had the appropriate mens rea, that is really for a jury to decide and not for the court to decide whether or not he acted knowingly, intentionally, unless you all are coming to the court for a bench trial. Otherwise,
That's
that's
not what
really
this
within the purview of a jury.
Right, Judge. We're agreeing to move forward for this on a suppression. Mr. Allen is agreed to give his testimony regarding the suppression and the dismissal motion, but he's not giving his consent to be heard in front of a jury right now.
No. I'm just saying
That's
that
the problem.
the mens rea part of it,
Mhm.
that would only come down to, jury trial or a bench trial, not for necessarily a motion to suppress or for me to determine in a motion to dismiss whether or not he exhibited the appropriate mens rea.
Okay,
That would be the state's argument, is it's outside the scope of this hearing and it should be a matter for the trier of fact.
All right.
fine.
So that objection will be sustained.
Mr. Allen, what's your understanding of free speech in the United States?
Then you have the freedom to speech, exactly what it means.
And do you think that that your attorney's office is a location where you can execute that right?
Objection, Your Honor, relevance, but outside the scope as well.
All right. That'll be overruled. I'll allow him to answer that question.
Absolutely.
Why?
Because one, it's America. Number two, it's because When you talk with your lawyers, supposed to be any kind of confidentiality.
In that recording, you were expressing some fear, frustration, and using some of this language. Did you think that you were committing a crime by going in and talking to your lawyer about these things?
Objection, Your Honor. Relevance and speculation.
All right, that'll be overruled. You can answer that.
Did you think you were committing a crime when you went in? I'm
Absolutely not.
going to pass the witness.
All right, state.
Just a brief moment, Your Honor. Sorry. Your Honor, the state has no questions.
All right, you may step down. Any other witnesses?
That's it, Judge.
State, any further witnesses?
No further witnesses from the state, Your Honor.
All right, then we'll close the hearing and we'll come back tomorrow morning and I'll hear arguments on both motions. All right, and with regards to no complainant being identified, is there really a need for a complainant to be identified if there's a threat? And I'm not saying it's a threat. These are just questions that I have, Mr. Allen. Is there a need to identify a singular person if there's an alleged threat that there will be bodies?
Well, I think a part of this is the nature of the charge is that this is a terroristic threat on a public servant. Although other public servants are discussed in the 12-minute recording that we heard, none of those public servants are specifically targeted in any of the statements that Mr. Allen made. They're talking generally about a number of things related to the legal strategy, related to the tactics that are being used. And basically, my client is speaking freely to his own lawyer.
All right, but I'm reading the indictment. Is there any objection to the court reviewing the indictment?
None from the state, Your Honor.
None here.
All right, so I'm reading the indictment and the indictment reads that on or about April 21st, your client did threaten to commit an offense involving violence to a person, namely, and then it says to kill people with intent to place the public or a substantial group of the public in fear of serious bodily injury. So according to the indictment, it's saying a group of people and not necessarily a person who's a public servant.
Of course, Judge, we do recognize that that's what the indictment says. We accept that that's the indictment generally, but we do have issue with the idea that this statement has been taken out of context. He's not particularly naming that he's going to do anything to the court or to the courthouse or to any of the people that work here. I'm also, I think you should know, I've been practicing 15 years and I work in this courthouse every day. And I don't feel like Mr. Allen is a threat to this court either. Further, when we talk about this, Mr. Allen's testimony reflects a constitutional innocence to him because he testified that he believed he was speaking confidentially with his own lawyer. He had no intent to harm anyone. He was not emotionally stable at that point because of the difficulty that he was having with his custody matter. So he was also shocked to learn that the words that he mentioned in his own lawyer, where he has an expectation of privacy, were being recorded and being used against him to third parties.
All right, so do both parties stipulate that a client's conversation with his attorney in a legal capacity is confidential, that that's the bar? Do both parties stipulate to that?
The state understands that confidentiality bar is there with exceptions.
Exceptions, yes. All right, so do both parties stipulate?
The state stipulates.
All right, so then the next question I have of both parties, is there an exception? And I think both parties know the answer to the confidentiality if there is a threat of violence or if there is a threat of a future crime.
Yes, the state is aware.
All right, and defense, do you stipulate to that? His saying he's not afraid of anything about the case in reference to the pending civil case, not the alleged actions that we're here for today? I thought that's what he testified to.
Well, and, I do know that, what we're really talking about is that the lawyer that testified, that was this man's lawyer, he continues to try to expand and express that he's in deeper fear than he was in the moment. And I think that's a vital distinction, because if there's a terroristic threat, I think that his action should be immediate. But rather, what Mr. Ireland did, he didn't immediately call 911. He immediately called the the amicus attorney. He thinks he doesn't remember that, but we believe that he called the amicus attorney because we got a bill for that. And then further, he calls the Texas Bar Hotline, which is going to favor him making this disclosure, at least to mitigate the immediate harm. But I think on retrospect, after 100 days in jail, the harm and the potential harm has been mitigated.
All right, so let's start here. State, do you want to address whether or not the communication that was testified, that is the basis for this alleged offense, whether or not that was privileged?
Yes, Your Honor, that was not privileged communication. It is detailed in the exception for furtherance of criminal activity, express or implied intent by saying if X does not happen, then Y is going to happen. If X, I don't get my custody, then Y, there's going to be dead bodies everywhere. That is both express and implied. Express, dead bodies, implied, maybe the how. But this was not privileged communications between an attorney and a client. And no, the shift of the communication that you heard, the audio recording, that statement comes at like minute 10:45. I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. So to say that the attorney, Mr. Ireland, wasn't scared, that was at minute 4. And Your Honor was correct in assessing that that was not related to the future threat that was going to come 10 minutes later, 6 minutes later. That is not privileged communication. Those privileges are to ensure fair trial, trust between parties. The privilege is not intended to grant people a right to threaten and to use words to cause a reaction like what happened in this case. It's not privileged.
All right, so the court is going to find that there has not been a violation of the attorney-client privilege under the disciplinary code 1.05C7. The court is finding that the recording is not illegal as Texas is a one-party consent state and the attorney knew that he was recording and he was a part of the communication. There was no third party in the room. It was Mr. Allen and his attorney. Now, with regards to the warrant requirement, both parties stipulated that this was that the defendant was arrested under warrant. So there's a warrant requirement that has been met with regards to that. Now, the next thing I want to talk to you all about is whether or not the communication to his attorney that we're here for, whether or not that's protected speech. And that's a part of your motion as well, client, Mr. Butcher.
Yes, Judge, that goes towards the motion to dismiss regarding this. I think there's some particulars in the recording and in what was discussed with Mr. Ireland on the stand. There are a number of statements that Mr. Ireland stated that tend to show that at the moment, Michael Ireland was not afraid. His own words and conduct tend to prove it. First off, Mr. Ireland said, you can fire me if you want. If you think I'm not doing my job, then go ahead. I think the implication from that is that Mr. Ireland had a calm and professional demeanor and he was not in fear. Further, Mr. Ireland said, you're getting F'd. In that regard, he's aligning himself with the client emotionally and tactically. And I think that matters because he's continuing to engage in this as not somebody that's looking for a criminal intent, but he's looking for a way to align himself with his client and think about the custody case strategically and tactically. He even says, I agree with you when Mr. Allen indicates that he is concerned and afraid because of some coincidences that were happening in that litigation. Further, they even talk about subpoenaing a gentleman named Sherwood. So Mr. Ireland is strategically engaging regarding the subpoenas that he's going to issue and the work that he's going to do in furtherance of that custody case. Now, I realize that this court isn't about reviewing a custody case in any way. But what we think is that Ronald Allen's testimony reflects constitutional innocence because Mr. Allen testified that he believed he was speaking confidentially with his lawyer. He had no intent to harm anyone. He was emotionally distraught, particularly due to the custody losses, and he was shocked to learn that his words had been recorded. When we get further into this, Ronald also expresses his own fear in the recording because he says, "I'm scared for my life, dude." That's not the speech of a would-be assailant. It's the language of a man trying to make sense of what he perceives as an unjust legal system. In my motion, I mentioned a number of cases that are constitutional cases, and one of them is the Watts case. In the Watts case, in a 1966 anti-draft rally in Washington, D.C., an 18-year-old draft dodger made the following remark, quote, "If they ever make me carry a rifle, the first man I want to get in my sights is Lyndon Baines Johnson, LBJ." This, by the Supreme Court, was interpreted as a threat. This was interpreted as a threat by the authorities under the United States Code regarding terrorist threats towards the president. But the Supreme Court found in 1966 that they reversed the conviction, holding that Watts' statement was political rhetoric and not a true threat, and therefore was protected speech under the First Amendment. Now, this applies because the context matters. True threats are not protected speech, but the government must prove that the speaker intended the statement to be understood as a serious expression of intent to inflict harm. So hyperbole, exaggeration, or emotional venting, even if it's crude or alarming, doesn't qualify as a true threat. Lower courts later differed on the objective versus subjective standard on this, but Watts did emphasize the importance of both context and intent. In reference to Ronald's case, this also was a vague and conditional statement. It was delivered in a nonviolent setting, and it was interpreted literally by the government, despite clear indications that it was a figurative rhetoric that Mr. Allen was engaged in. Similarly, this case, in Ronald's case, it was emotionally charged, but it was conditional, and it was made during a private dispute involving custody. Now, Texas courts regularly apply the Watts principles. There's another case called Lopez v. State, where 631 Southwest 3D 107. In that case, the court explicitly cites the Watts case in evaluating whether a defendant's statements were true threats or protected speech. And in that case, it was held that the defendant's statements about bombing a school were not protected speech because they were specifically targeted and intended to be taken seriously. But the key takeaway on that is that Texas courts always adopt the contextual approach from Watts, looking at the surrounding circumstances, the intent, and the audience. In this case, those factors are highly in favor of a dismissal for my client. Further, there's another case called State v. Hansen, where the courts recognize that political hyperbole, even if it's violent in tone, may be protected under Watts. There's also the Dorset v. State case, where a defendant told officers, "Y'all better wear your vest because I'm going to start shooting." This was held as a true threat, but only because of the content, including a history of violence and the ongoing criminal conduct resulting in the officers responding in that case. Watts influences Texas law even without being codified. Texas courts do adopt some options of Watts because they talk about a true threat test as a conditional limitation in applying the Criminal Code 22.07. The judges are to act as gatekeepers even if the conduct appears to violate the literal text of the statute, but it must pass the Watts standard in these matters. There's another case, more recent in 2015, the Alanis v. United States case, where the Supreme Court held that punishing threats require proof of a mens rea or a subjective intent to threaten. The person cannot be convicted. The Alanis case holds that a person cannot be convicted based on how others might perceive their words. Rather, the speaker must actually intend actually intent for those words to instill fear or communicate a threat. In this case, the full transcript demonstrates Ronald's alleged threat was embedded in an extended stream of anxious, erratic speculation and emotionally charged grievances, where at one point Ronald even says, "I got called into jury duty the same week in the same courtroom. The odds of that is like me winning the lottery 20 times in a row. Bro, it didn't even happen." He further elaborates, "Hey, I had jury duty, dude. They asked me certain questions and they made me sit there all day. The same effing judge. They wanted to know what I knew and if I recognized those other two girls." When I read these statements, they don't seem to be statements of intent. They're statements of subjective fear, suspicion, and confusion. And it's exactly the kind of talk one might share only with their lawyer while trying to process whether the system is fair or rigged. So here, far from planning any violence, Ronald was exploring whether something conspiratorial was happening to him, and he was seeking his lawyer's validation and advice. In the same way in Alanis, the court emphasized that convictions under federal threat statutes require subjective intent. So the speaker must actually have intended the words to be understood as threatening. In that case, the court reversed a conviction that was based on an objective, reasonable person standard and holding that omitting a reference to intent in a criminal statute does not mean that the mere negligence is the appropriate mental state. So here, we might agree that the words that Ronald used in his lawyer's office were negligent because they might be interpreted as a threat, but his intention, and the state hasn't shown that his intention was to make a threat
But
to the general public.
at this juncture, isn't whatever your client's intent, that's something for a jury to decide? Or if this were a bench trial, then it would be for me to decide. But is that correct? That that's something for the jury to decide what his intentions were. At this point, my only, based upon your motions, what you're here for is whether or not there was a warrant issued. It's been submitted that there was a warrant issued. Both parties stipulated to that. Whether or not the communication with his attorney was privileged or not. I'm finding that the communication was not privileged because it falls under the exception of a threat that was being made. So the threat that was being made, that wasn't privileged communication. It falls underneath the exception. Now, whether or not Mr. Allen, whether or not you meant that, or whether or not it was intentionally, knowingly, or whatever the mens rea may be, that's something for a jury to make that determination. At this point, this court, I'm just making rulings upon motions that are presented to me. But there are some things that I legally am not allowed to make rulings on. One of them is determining what your mens rea is, whether it was intentionally, knowingly, recklessly, whatever it may be. And that would be what is actually in the indictment. So in the indictment, they're stating that you made a threat with the intent to place the public or a substantial group of the public in fear of serious bodily injury. So at this point, for this hearing, it is not within my jurisdiction or purview to determine whether or not you made a threat with the intent to do whatever, right? That would be something that a jury would decide. Now, if you were having a bench trial, then I would be in the place of the jury, and then I would listen to evidence and make a determination of whether or not I believe beyond a reasonable doubt that the state has met its burden based upon what's in the indictment. You understand?
Yes, ma'am.
So what I can tell both parties is that, one, there was a warrant. Both parties stipulated that a warrant was issued. Number two, the court is finding that while your communication with the attorney is confidential and private, right? But the exception to that, one of the exceptions, if there's a threat that's being made. So the communication, the court is finding the communication that you had with your attorney, the court is finding that that falls under the exception of attorney-client privilege. So, State, you want to address the defense's other points, please?
Yes, Your Honor, we would start with First Amendment does not protect speech like this. A true threat, and Your Honor, true threats encompass those statements by which the speaker communicates an intent to commit an act of unlawful violence to a particular individual or group of individuals, regardless of whether the speaker actually intends to carry out the threat. And this Garcia case quotes a Supreme Court case, Black 538 US, and that's at 359. The reason that the First Amendment does not protect violent speech like this is to promote public safety and curb misdirection of resources. When defense brought up Watts, that is specific to the draft. And the gentleman in that case didn't know if he was or was not going to be drafted. So it was hypothetical, hyperbolic. The defendant here is making direct threats. Now, this language is not ambiguous or exaggerated. If X, then Y. When defense says, well, look at the attorney, Mr. Ireland, he did not express fear. He did not interrupt or disengage. In the 12-minute conversation, it was 1 minute and 25 seconds after being threatened by the defendant that his attorney, his own attorney, says, get out of my office. Subsequent to that, this attorney paid for active shooter training for everyone at his office, paid for them to become familiar with guns, concealed carry, locked the doors to his office. The defendant scared this man, and that is the state's argument. This is not protected speech. It was intended to make a response. It was not a joke. It was not to be taken lightly.
All right, this is what the court is going to do. The motion to dismiss is denied. The motion to suppress is denied. I'm going to schedule this for a jury trial for September 30th. And so if there are more motions for the court to hear, please bring your motions before that date. Ms. Ferguson will make sure that it is placed on the docket.
Judge Boyd denied both motions and set the case for jury trial, but it never got that far. Allen pleaded no contest to the terroristic threat charge and applied for deferred adjudication. Judge Boyd granted it, placing him on 5 years of community supervision. That means if Allen violates those terms, he returns to court, where the third-degree felony conviction can become final, carrying 2 to 10 years in prison. Attorney-client privilege is broad, but it was never meant to shield future harm. Under Texas law, once a conversation crosses that line, confidentiality can become a duty to report. Do you think that line was crossed in Allen's case? Drop your thoughts in the comments, and subscribe for more cases like this.